So good afternoon. You're all very welcome along to this afternoon's webinar, HR issues arising from COVID-19. And we're delighted to introduce Kirsty Kavanagh of Kavanagh & Co. Solicitors are going to take us through the issues. Just to let you know, so if you have any questions as we go along, please feel free to use the questions and answer function there. It should be just located, I think, on the bottom of your screen. Or you can also post questions and comment through the chat function there as well. We will take Q&A as well at the very end. In the meantime, I'll hand you over to Kirsty and enjoy this afternoon's webinar. Thank you.
Good afternoon, everybody. I hope you can hear me properly. Brian, is that working properly?
It's coming through fine for me, thank you.
Yeah, perfect. So as Brian said, my name is Kirsty Kavanagh. And first of all, thank you to Brian and to the Chamber for inviting me to speak to you this afternoon on HR issues arising from COVID-19. As Brian said, I'm the principal in Kavanagh & Co. Solicitors based in Carlow. I've presented a number of courses for the Chamber to date. They've all been around HR and employment law issues. And we're seeing a lot of inquiries in relation to that at the moment, as well as been extremely busy, unfortunately, doing wills for people because people are very concerned in relation to COVID-19. So that's just our contact details there. So there's a lot of issues arising at the moment in relation to employment and concerns that people have, and that's coming from both the employee and the employer. So I'm going to cover a number of issues to include layoff, short time, redundancy, employees returning from maternity leave, and that is a big problem because employers are hugely vulnerable when they are dealing with employees who are returning from maternity leave and all issues in relation to maternity leave because of the protections that are there. Then issues that arise from working from home, such as the Organisation of Working Time Act and health and safety. Communication, there's issues arising in relation to WhatsApp groups and different emails that have been sent around in groups. Then health and safety during COVID-19, GDPR, email and internet policies, employees' right to leave, so things like holidays, parental leave, force majeure. Questions are arising in relation to whether employees can elect or not to take that type of leave and whether an employer can ask their employee to take holidays. So we'll cover all of that, and if there's any questions then at the end we can deal with them too. So the first thing then is layoff, and some employers may already have faced the layoff choices or options as to whether they have to avail of that. So layoff is where an employer is unable to provide work to an employee for which they are employed to do. A layoff is a temporary suspension of a contract during which an employee receives no work and, more importantly, receives no payment from the employer. The employer has no right in law to lay off employees for whatever reason unless this is provided for in the contract of employment. So if an employer was to seek advices from me about whether they can lay off an employee, I would say to them the first thing I want to see is their contract of employment. And I would review the contract of employment to see if it mentions layoff and short time. I would also review the contract to see if the contract says layoff without pay. It's hugely important that that is checked, because if it doesn't, then your right to layoff is going to be impacted. Now, layoff can be affected where there is no provision in the contract of employment with the agreement of the employee. So a lot of employees would be willing to work cooperatively with the employer because they want to safeguard their job into the future. But as we know, that's not always the case. And when you get into a larger group of employees, it's going to be harder to get consensus. Layoff should only be used where the employer believes that there will be work again for the employee. Otherwise, you're looking at redundancy. Most unions will support a genuine layoff situation as they want the employees to return to work. The key word in relation to layoff is temporary. Now, I suppose in relation to COVID-19, none of us know what we are facing into. None of us know how long these lockdown provisions are going to be in place. So our hope is that the layoff is going to be temporary in nature. And the key thing there to remember is that the employer, in my opinion, is going to be viewed through the lens of the reasonable employer facing COVID-19. And that is the view that the Labour Court, in my opinion, are going to have to adopt. So therefore, you know, I've mentioned that layoff, is it provided for in the contract? Layoff, you know, is it by way of agreement with the employee? In this particular case, because of the nature of COVID-19, if there is no provision within the contract of employment, and if you haven't got a general consensus, it would be my belief that the Labour Court would accept that where there is a genuine layoff situation, that it would be permissible to lay an employee or a group of employees off without payment, but that remains to be seen. But I certainly would not recommend that an employer would simply go ahead and lay employees off without any advice has been received from both solicitor and accountant in relation to that, because, you know, we have to work on the basis that in a couple of months' time we are going to be back trading. So, and trading effectively, and that means that you will be a mark in the event that an employee takes a case against you. And what I mean by that is that there will be money there for the employer or the employee to recover. So I was talking to two employees yesterday who were taking a case. We're leaving it for 2 to 3 months before we issue our WRC claim to vote on for unfair dismissals cases, because the employer has not acted in a reasonable fashion in relation to COVID-19. But we're waiting for 2 to 3 months because we need to make sure that the employer continues to trade, because otherwise, from my point of view, I need to make sure that I'm going to get paid. But I actually do not want to be asking clients at this moment in time to pay money on account to me if we don't know that the case is going to proceed because the employer stops trading. And that's in cases where, you know, it would be questionable as to whether those employers will continue to trade. So if we work on the basis that you are going to continue to trade, and that there is going to be money recoverable, then you don't want to leave yourself in a position where you are actionable by the employee because you have not laid them off in a proper fashion. I think communication is key throughout any action that you take with employees. And again, that is much easier where you have a smaller group of employees as opposed to a larger group. Now, the other thing is in relation to layoff and short time, notice is key. So advance notice must be given, and preferably in writing. Now I'll go through what kind of notice must be given later on in the presentation, but it is essential that that notice would be given. Notice depends on the circumstances. So in some instances, notice might only be a couple of hours. It depends on your employment and it depends on the sector that you work in as to what is reasonable. So say for instance in hotels, they were immediately shut down. So, you know, it would be very unreasonable to expect that an employer would keep paying employees for a period of a month and their notice period would be a month. So just be very careful again and to seek advices in relation to that. So then moving on then to short time. Short time is where an employee's weekly pay or hours is less than 50% of their normal weekly pay or hours due to a reduction in the amount of work to be done for which they are employed to do. So an example of that would be a 5-day week reduced to a 2-day week. So moving on then to redundancy, and I haven't done a huge amount in the presentation in relation to redundancy, because realistically redundancy could be a presentation in its own right. So I'm trying to do a lot of issues in relation to the different HR groups or the HR issues that we are dealing with at present. So just then to touch on redundancy, it is absolutely essential that when redundancy situation arises, that it is the role that is made redundant as opposed to the person. The onus is on the employer to justify the dismissal. Furthermore, you will have to demonstrate that the dismissal was on grounds of redundancy, and the following criteria will have to be met. So 1, that a genuine redundancy situation arose. 2, the dismissal resulted wholly or mainly from that redundancy situation. And 3, that the employee made redundant was fairly selected. So I did speak to an employer in recent weeks who said they were going to use this opportunity to cull their staff to get rid of certain employees that they do not want. Very, very dangerous to be using that type of language. You cannot use this situation to simply cull the staff that you no longer want in your employment. If you are going to have redundancies, there's going to have to be a very fair and transparent mechanism deployed in order to select the employees' roles that are going to be made redundant. And I say role, it is not the employee that is going to be made redundant. So if you're not going to go on the basis of first in or last in, first out, then you would have to have a selection criteria set out. And I would say that an employer should not embark on that without talking to their accountant, and that an accountant or some financial consultant would come in, do a report, and analyze what areas of the service or the sector that the employer is working within is underperforming, and where cuts have to be made, so that in the event that an unfair dismissal case is taken, or if multiple unfair dismissal cases are taken, then you have the report to work from, and that you can, if necessary, call your accountant to give evidence on your behalf to say that there was a financial reason as to why the redundancy had to be taken. So I'm not going to read through the Redundancy Act, but I have quoted there from Section 4 of the Unfair Dismissals Act, and you'll note that there are different sections there where it says F19 and F20. I have taken this section from the amended Unfair Dismissals Act. So the wrong thing to do if you're looking up a piece of legislation is to look at the Irish statute book, because there are so many amendments to the employment law legislation in particular, because it hasn't been consolidated. So if you were to go to the Law Reform Commission website, and you can go to the pieces of legislation there, and they have been marked up with the amendments. So you can read that in your own time, and any questions you can come back to me on it. So one question that I was asked to cover in this seminar was redundancy by default. And that is where an employee has been put on layoff, and then the employee elects for redundancy. So prior to the emergency legislation, if an employee had been laid off or in short time for firstly 4 or more consecutive weeks, or secondly 6 or more weeks within a 13-week period, of which not more than 3 are consecutive, the employee could notify their employer in writing of their intention to claim a statutory redundancy payment, assuming they satisfied there's certain criteria that they have to meet. So the notice had to be given at the latest within 4 weeks after the layoff or short time has ended. That has caused a massive amount of concern for employers, because some employers are already at the stage where their employees are at the 4-week mark. So There is protection from redundancy by default, and redundancy by default is the how I'm describing it. There is no legal term on that, but the Emergency Measures in Public Interest COVID-19 Act 2020 amends the Redundancy Payments Act 1967 with the effect that any employee who has been laid off or kept on short time due to the effect of the measures due to COVID-19 will not be entitled to claim redundancy during the period 13th of March 2020 to the 31st of May 2020. So the last week in May, employers who have employees on layoff would want to be checking in with their advisors to ascertain if there has been an extension to that date. I would be of the opinion that there will be an extension to that, given the fact that the lockdown we think is going to be extended further. But I can't obviously guarantee that it will be, so we'd want to be keeping a close eye on that. So moving on to the next slide then is what happens post the 31st of May 2020. The protection may be extended. If not, the employee can make a claim on an RP9 form, and that's from the WRC website. The employer can A, accept, so they can accept that the employee is going to be made redundant, or B, they can counterclaim and contest the claim. A counter notice by the employer must be lodged within 7 days, and that is where the employer is contesting the claim. An employer must give written notice, a counter notice within 7 days of the employee's redundancy notice. By issuing a counter notice, the employer is effectively promising that not later than 4 weeks after the date the employee I'm just going to move this up, sorry. By issuing a counter notice, the employer is effectively promising that not later than 4 weeks after the date the employee notified them of their intention to claim redundancy, the employer will be in a position to provide work lasting 13 consecutive weeks. Now, again, from an employer's point of view, give me my crystal ball and I'll tell you whether I'm going to have 13 consecutive weeks notice, because from my understanding of listening to the HSE and the Department of Health, we have at the moment these restrictive measures. There at some point is going to be a lightening of those restrictive measures, but until we have a vaccine in place, the government is not going to give us any guarantee that those restrictive measures are not going to be put in place again. So again, as I said before, give me the crystal ball and I'll tell you whether there's going to be 13 weeks consecutive work. So I think all we can do is work with the information that we have at a particular point in time. The employment law legislation is not designed to deal with a situation like COVID-19. So it is going to be an evolving position. And there are going to be amendments, I would imagine, to the legislation as matters roll on. And no doubt there will be advisors within the different government departments going through these issues. I know that the Law Society, to be fair to them, I'm often a critic, but they have been very, very strong in terms of their representation on behalf of employment issues that are arising, not just affecting affecting solicitors and solicitors' practices, but in general in relation to the legislation that is coming out. So no doubt they will be making representations in relation to this. So if the employer serves the counter notice within the 7 days and the employer does not then have 13 consecutive weeks of work, the counter notice is invalid and the employee is entitled to a redundancy payment. The employee is entitled to a statutory redundancy only, and he or she is not entitled to a redundancy or to a notice period, as he or she is the party terminating the employment. So in the event that the employer was the one who was terminating the employment, they would have to pay the notice period, but because it is the employee employee who was serving the notice, they are not entitled to the notice payment. Again, that's just going to be a wait and see in terms of whether the deadline of the 31st of May is extended, and then in relation to the notice periods, etc. So what needs to be done in effecting layoff? Again, the employer must believe that the layoff or short-time working arrangement will not be permanent. This belief must be honest and reasonable. So again, I go back to my example earlier on of, the employer who was going to use this opportunity to try and cull staff. We need to be very careful. It is quite easy for an experienced chairperson within the WRC to ascertain what employee or what employer is genuine and who is trying to make hay when the sun shines. So I think a stitch in time saves 9. You need to get your advices. You need to make sure that your I's are dotted and your T's are crossed, and that you do work with your employees in an open and transparent fashion. So the employer must notify the employee in writing before the cessation of or reduction in work. Failure to notify an employee of the layoff or short time working may result in employee claims, including a claim for statutory redundancy payment or a claim for non-payment of wages. It is essential that the employer complete the form RP9, which can be found on the WRC website. There is no minimum notice period provided for under legislation. An employer must provide notice which is reasonable in the circumstances. So this goes back to what I said earlier on, and that due to the nature of COVID-19, it is expected that the WRC would treat a reasonably short notice period as being sufficient. And again, that depends on the type of work that you are in. Employers should explain to employees the reason for the layoff or short time working, and keep employees regularly informed of the situation during the layoff or short time. Communication and transparency are key. Again, selection for a layoff and short time must be objective, impersonal and fair. And I know I keep saying that, but unfortunately, I have seen an awful lot of employers get into hot water because their selection criteria has not been objective, impersonal and fair, and that is in the that's in relation to redundancy and in relation to layoff. So just in terms of the practical things, so you should inform the local social welfare office directly of workers being put on layoff for a short time. In the event that you have a significant number of employees who are going to be put on layoff or short time, I would recommend that you would just make direct contact with the social welfare office. Alternatively, a note can be given to the employee concerned, which can then be presented to the local employment exchange by the employee. And I'm just setting out the particulars there. So name and address of employer, name and address of employee, employee's PPS number, date of layoff, possible duration of layoff or systematic short time. In terms of employees going on layoff, gross earnings from 1st of January to last day of employment, amount of income tax paid by the employee, amount of PRSI paid, and then in the case of employee going on short time, details of short time working arrangement. Okay. Now, another issue then, if we move on to pay cuts, is can you unilaterally impose a wage cut on an employee? And the short answer to that is no. And I have never seen a contract of employment where the employer has a right to make a deduction to an employee's wage, because realistically, what employee would sign it? I certainly wouldn't be recommending that any employee would sign a contract of employment that had that provision in it. So if there's going to be a salary cut, you must bear or have reference to Section 5 of the Payment of Wages Act 1991. And Section C of that states that in the case of a deduction, the employee has given his prior consent in writing to it. So that's the only mechanism there where you can make reductions to a employee's wages. Now, where you have a union, that's a completely different set of circumstances. So you would have collective bargaining where the union would go in and negotiate in relation to a group of employees. So that's completely separate. I have no difficulty if people want to contact me on a one-on-one basis if you have a unionised place of employment, and we can go through that. But in the event that you do not have a union in your place of employment, and where you are considering wage cuts, there will have to be consultation in relation to that. And consent, fine and dandy, it is consent in writing that you must have, because it's all very well and good, you know, we're all under pressure at the moment, and you may not have time to, you know, to get something signed. Again, I go back to a stitch in time saves 9. You absolutely have to have it in writing. Again, we're not in a situation where we have all of our employees on site because of social distancing. What you can do is just send an email saying, further to our conversation today, I know that you have accepted a pay cut. If you have to do that, it's better than nothing. You know, so it is recording it in writing. And again, if I go back to just in relation to notice, I would not be sending out a letter by ordinary post. So again, if you want to keep your costs down and you don't want to use registered post, if you even send it by email, at least you have a record of it being sent. And if you want to do post as well, that's fine. But anywhere where you are given an employee notice, or in the event that it is something that may be used as evidence into the future, you're better off having proof of the fact that the document was sent. Okay, so employees returning from maternity leave. This definitely will cause issues and is causing issues, because, and I can see this from both points of view, you know, an employee who is finishing up maternity leave is entitled to return to the workplace, and that is set out in the Maternity Protection Act. But it is difficult for employers at the moment in terms of, you know, selecting employees for layoff and having concerns in relation to employees who are returning from maternity leave. So you might have a situation where a person is returning from maternity leave and they have a child who has been quite sick throughout the maternity leave and who is in the vulnerable group. You need to be very, very careful with that. And you know, that's in general, you need to be very careful with people who are in a vulnerable group, or if they have persons at home who are cocooning, or if they are immunosuppressant, etc. But I'll talk about that again in a minute. But from the employer's point of view, it is very difficult, but we are where we are in terms of the legislation, and it is fine if you have employees, all of your employees in the workplace are on layoff, or if all of them are on the wage subsidy scheme. If you treat your employee who is returning from maternity leave in exactly the same fashion, fine. There's no issue in relation to that. The issue arises where you have some employees on layoff, some on short time, and some on the wage subsidy scheme. What do you do with the employee who is returning from maternity leave? The safest thing to do is that they would return, and they would return to the job that they did previously. If you are in that position, I would advise you to seek advices. If you are not in this boat where all of your employees are being treated in the same boat, then you need to seek advices, because the implications are significant. So if an employer treats their employee that is returning from maternity leave in a different manner, then they run the risk of a claim under the maternity protection legislation, where an award of up to 26 weeks can be paid, and they run the risk of equality cases being taken as well. So I just hit on there a minute ago in relation to employees who are immunosuppressant or who are cocooning for whatever medical reason. So if you are aware that you have an employee who has a medical issue, I would advise that you would obtain a letter from their doctor or from them to state what the position is regarding their being able to work. So it is very difficult at the moment to be asking doctors to be writing letters to confirm whether someone is safe to work or not. If somebody is on immunosuppressant medication, they shouldn't be working. If they can work from home, fine. I have a very significant bullying and harassment case that we issued proceedings on a year ago, and my client is immunosuppressant and has had a kidney transplant. And the employer, who is a large body with thousands of employees, sent around a circular to asking the employees who were cocooning or who had any medical illnesses, and they set out the HSE document for medical illnesses, to contact them. My client did that. My client was actually self-isolating in her place of employment, had taken all of the precautionary measures herself. The employer didn't comment on them at all, and my client was then asked to get a letter from the doctor. Now, this was the first week of the restrictions, so it was actually impossible to get in contact with any GPs. I think GPs now are a little bit, they're not as busy because people with everyday illnesses don't seem to be going to their GP, but she couldn't actually get in contact with her doctor. And the employer was, in my opinion, negligent in the manner in which they dealt with the employee. It was very, very clear from the documentation that it issued from the HSE that she was in the vulnerable group and that she should not have been in the workplace. So I haven't covered that in the presentation, but it is something to be very mindful of in terms of, you know, health and safety. Do you have any vulnerability or liability if you do not safeguard an employee? If you have an employee who you know who has a medical illnesses, if you have an employee who you have previously sent to OC Health and you know that there is an issue, well, then you're on notice of it. So you just need to be very careful in relation to that. So moving on then to bullying and harassment. So maintaining contact with your employees is key at the moment, and I do think it's hugely important that, you know, you would have regular team meetings through whatever form. And, you know, look, in my office we use a WhatsApp group and it's great, but you do need to keep a check on it in terms of, you know, we're all have been inundated with these videos about COVID-19 and different videos coming in, and there's the groups, the WhatsApp group for your family, there's the WhatsApp group for your friends, and the content has to be varied according to the audience. So what might be okay to send on a group with your friends may not be appropriate, most likely isn't appropriate for a group from work. So employees working from home are still employees, and they need to be informed that the WhatsApp group, you know, you can't be using that for sending of material that is offensive to particular groups. Now, in terms of some of the innocent videos that are going around in relation to WhatsApp, what's innocent to me might not be innocent to you, so we do have to bear that in mind. And most employers at this stage would have social media, email and internet policies. If you don't, you should have them in place, and employees need to be reminded that it is absolutely essential that they adhere to them. In the event that there is offensive material put up on a WhatsApp group, then that needs to be taken down ASAP and an investigation launched. And if disciplinary action is needed, well, then so be it. And again, I wouldn't be putting off investigating the claims that are initiated by complaint by an employee. So health and safety, and I touched on that in relation to where an employee has an underlying illness, but I didn't go into immunosuppressant and all that. But what I'm saying here is that employees are under a legal obligation to cooperate with the employer so far as is necessary to enable compliance with the relevant statutory provisions and company policies. There is an obligation on the employee to take reasonable care to protect their own safety. This includes following the advice from their GP, healthcare providers, and the HSE as appropriate. So, in relation to certain employees, if you have a small place of employment, you may know whether there are employees who have vulnerabilities. But again, you haven't got a crystal ball. So if there are employees who haven't informed you, well, there's very little that you can do about that. But in terms of return to work, etc., I certainly would be putting out a circular, putting an obligation on employees to inform you in the event that they have an issue returning to work, or if they have a vulnerability, whether they should be cocooning, etc., and put an obligation on them to notify you. So then the last point, an accident or incident that takes place outside of the office whilst the employee is conducting normal work duties should be reported to the company, and where required to the Health and Safety Authority is normal. So, okay, employees working at home, just because they're working at home doesn't mean that because the accident did not happen on your premises, that there's no responsibility. So I would say that all incidents should be reported, and then you whittle down as to whether there's an issue or not. But once there's an incident report form completed, or whether if it's logged in some manner, that is sufficient, and then you can decide whether an investigation is warranted. Now, this is not a GDPR seminar, but I think it would be remiss not to mention it in some way, because I am working from home. All of my staff are currently working from home. We're taking it in rotation, going in and out of the office. And we have to be mindful of security of data, because obviously, given the nature of our business, the data that we have would be sensitive. So what did I do? All of my staff have laptops that were supplied by the office. We can only connect into our content or our files through a VPN, which is secure. We've worked with our IT company, Joneses, and they set us up so everything is safe and secure. So they are the things that you need to be doing. So the company, the employer, needs to ensure that data security is maintained where staff are working from their own homes. Where remote working involves the transmission of confidential data outside of the workplace, the employer will need to ensure that its systems are designed to enable the safe transmission of such data. They will need to ensure that they have robust IT systems in place with the necessary safeguarding is important, and so too is skills and awareness of the remote worker. Reminders and online training can be utilised to refresh skills in this area. So we're even seeing at the moment getting a lot of spam in, and employees need to be reminded not to be clicking on them. Some employees are using their own laptops. This is not advisable. And the reason why that is not advisable is that how do you then obtain the laptop? You have no right to say that laptop is to be returned to the office. So you need to get the content removed from the laptop as soon as is reasonably possible. In the event that data can be submitted to the office and then removed off the laptop. Again, it depends on what is feasible and what is not feasible, depending on what type of work you do. Employers need to be careful that the IT solutions used by them do not store their data outside of the EU. I'm not an expert in relation to that. I know Gary Evans, and there's lots of different people on the within the chamber in Carlow who would be able to advise you in relation to that, in relation to Zoom, etc., as to what data is contained outside of the EU and GDPR regulations. It is not my area, but just to highlight it as being a possible area of concern. Now, again, with the employee working at home, that does not mean that you know, their working hours are not your obligation. If you don't keep them in check, then you are potentially leaving yourself open to a claim pursuant to the Organisation of Working Time Act. So the employer is required to ensure compliance, and this includes ensuring that working hours and rest breaks are occurring in line with the legislation, and that records of the days and total hours worked in each week by the employee are maintained. So just on that, I know from quite a lot of my friends actually that they're having difficulty with working during their normal day because of pressure on Wi-Fi. And some of my friends are getting up and they're working from 5:30 until 9 o'clock, and then they're working again in the evening when the internet is faster. So again, what I would say is that you just work cooperatively with your employee in relation to that. If there is a change, like I have it with my team, there has been changes to working hours, but we did that through working cooperatively with one another, and it just has been recorded through emails that there has been a change, but they all still have their rest breaks. So moving on then to holidays. So an employee on layoff or short time may be entitled to annual leave under the Organisation of Working Time Act. The amount of annual leave is dependent on the hours physically worked during the year. You do not accrue annual leave during layoff, but you are entitled to take annual leave that you accrued before being laid off. So with public holidays for layoff periods, you are entitled as an employee to be paid for public holidays up to 13 weeks post your layoff. So again, just in relation to working from home, to remember that employees who are working from home are entitled to claim €3.20 per day or €16 per week tax-free. Employees are not entitled to elect to work remotely. This employer rests with the employer. So you just need to be careful in relation to that. I do know that some employers are of the opinion, well, look, we can't just select groups of people who can work from home, so we're going to have to just do it in rotation. And I think you need to actually do a risk assessment, and you need to look at what type of work can be done safely from home and what type of work just cannot be done from home. And then you do your social distancing then for those who are working when they're on site. Now, I'm talking about people who are actually legally permitted to work at the moment. So if I look at pharma companies at the moment, so pharma companies, if you have people who are office based and they are not an integral part of the production line, then why would you have them on site? If they can do their job effectively from home, and if you're set up for them to do remote working, it is about trying to reduce the number of people who are on site. So by doing your risk analysis and your risk assessment, you set out who can safely do their work off site, and that reduces the number of people who are on site, and that enables you to have the maximum amount of people in the area that you need to have on site. And that to me just seems like the most logical solution to it. And I think that as the restrictions are lifted, that's something that all of us are going to be obligated to do, so that you would have a risk assessment. And I had a case a couple of weeks ago in the WRC, and it came up as to whether a risk assessment was done. And my client, who's the employer, said, oh yeah, we always do a risk assessment. And okay, can you show me the documents? Oh no, it would be a mental risk assessment. So I do a lot of regulatory law as well, representing professionals who have been accused of misconduct. So one saying that is always used in regulatory cases is not written, not done. So in relation to risk assessments, not written, not done. So I think there will be an obligation on us to record, how did we select what employees were required to work on site? How did we record the mechanism for whether we were going to have certain staff in on certain days. So just encourage people to look at that now so that you're not caught on the hop when the restrictions are lifted. So if an employee chooses to self-isolate, they are not entitled to be paid. If an employee contracts COVID-19 or are medically required to self-isolate in accordance with HSE guidelines, they may avail of an enhanced illness benefit. Now, I haven't gone through the wage subsidy scheme. I haven't gone through any of the social welfare because there has been a huge amount of data put out in relation to the schemes. If necessary, if there's demand on it, if you get in contact with Brian and we can see if we can roll something out with maybe the accountants, but I think there has been a huge amount of data circulated in relation to that already, and Citizens Information website has a lot of content on it as well. So then questions have arisen in relation to paid and unpaid leave. So there are different types of leave that are that an employee is entitled to, and that's statutory leave, and I'll come on to that in a minute to advise as to whether employees can avail of that or not. So if you are not sick but you cannot go to work because you have a child to look after, or if you have a sick relative, you can ask for paid leave. If the employer cannot give you paid leave, then you can ask for statutory leave. Employees may request to take holidays, but that is at the discretion of the employer. Now, one thing just to note in relation to that is holidays are designed under health and safety to allow somebody to have a break. So it is questionable as to how much of a break an employee can actually get at the moment because, stresses as a result of COVID-19. So I don't know, in all honesty, as to what way the Labour Court or the Workplace Relations Commission would deal with an employee taking holidays at the moment. If it's a request, get the request in writing. I think from an employer's point of view, it makes sense that holidays would be taken, but you just have to be mindful of the fact that there may be a health and safety question there. I think, again, you just need to act reasonably. If it is a certain amount of leave that is taken through holidays, that may be permissible. The other thing to remember is if person has just a statutory holidays, I think that would be looked at in a different fashion than holidays over and above the 20 days. So, or if it's on a pro rata basis, if they work part-time. So if someone wanted to take, if somebody had contractually more holidays than the statutory limit and they want to take them now, I don't see that has been an issue. Again, if you want to take unpaid leave, that's at the discretion of the employer. You might have certain employers who just simply can't do without their employee, and we're all, put to the pin of our collar at the moment. So in an integral employee looking for unpaid leave, that might not be, it might not be workable at the moment. But what I would say is if you can work in terms of, changing rosters, changing hours, things like that. So employers have been asked to be as flexible as possible in assisting employees with care arrangements. This could include offering paid compassionate leave, allowing you to work from home, altering shifts so that you can coordinate caring between you and your partner or another person, allowing you to rearrange holidays, allowing you to take paid time off that you can work back later. That may or may not be possible. But again, you have to bear in mind the Organisation of Working Time Act. So if somebody already works a significant number of hours, then how are they going to be realistically able to pay them back? Then statutory leave. So there are different types of leave that are available, and I got a question in relation to force majeure. Force majeure is paid leave, but that, the definition of that is that it is leave for urgent family reasons. So COVID-19 would not be deemed to be urgent because we are notice of it. So urgent would be where an accident happened and you are urgently called away from work. Or if you are not in work and you're just not in a position to go to work that day or the day after because of something that has arisen. So parental leave, if you're looking at after a child up to the age of 12 or 16 if the child has a disability. Parents leave if you were caring for a child up to the age of 1 who was born after the 1st of November 2019. Normally, an employee must give 6 weeks notice if they want to take parental or parents leave. You do not have to pay an employee when they are on parents or parental leave. So that might work with the employee, and it might work for you. But what I would say to you is, again, you must have this documented, and I would say it's not sufficient that you just have an attendance done up and put into the personnel file. I would say that you need to have a chain of emails where you record the fact that the employee has requested this and they have had the opportunity to say, well, that's not what I said, or no, that's not what I want, as the case may be. And that is it. So if there's any questions, Brian can put them to me now, and if you want to put on your mics if someone wants to ask them, but Brian, I'll let you handle that element of it.
No problem at all. Thank you very much, Kirsty. Quite a lot of information there. I know it'll take a bit of time for some people to work through it, but if you have got any questions, flag it up there in the chat or pop it into the Q&A session. And as you will have noted, while the presentation was going on, I'd mentioned there as well, we will arrange to send out copies of the slides, because there is a lot of content in there, and it's important to have the right information as well. So and I know it can be difficult to take a note, so we'll make sure that we have got the slides sent out to everybody afterwards. I don't see any questions at the moment. I think you've really gone into in-depth. So
the other thing is that I will put an email to Brian on this, that we will do a 1-hour free consultation for all Carlow Chamber members on HR issues arising from COVID-19. So that will be there, and Brian can circulate that. I haven't even said that to Brian. I forgot to say it to him earlier on. So if people do have questions on this, we will be in a position to deal with. Just contact the office as normal, and the girls will schedule a conference call, whether MS Teams or whatever way you want to set it up.
No problem at all. That's brilliant. Yeah, no, so I don't see any questions coming through there just now at the moment, but we will share the details out. From me in the chamber, a big thank you to Kirsty for taking the time to share that information with us and take us through the webinar this afternoon. We will have the links and information out to you then shortly as well. If you are available tomorrow, we have another webinar taking place at 2 o'clock in the afternoon again, and that has been delivered by Sergeant Peter McConnon of the Carlow-Kilkenny Garda Division, and he's going to discuss keeping your business safe and secure through COVID-19. And that's followed on Thursday by Paul Byrne of Business IT Solutions, and Paul and his team are going to discuss remote working solutions, and to help you to look to see how you can get the best and what fits best for your solution. But in the meantime, I think if that's all from us here at the Chamber for now. Again, thank you to Kirsty. Thank you very much to everybody for joining us and taking part. And we hope you keep safe and well throughout COVID-19. Thank you.
Thank you, Brian.
Thanks, Kirsty. Thanks, Brian.
Thank you.